In what ways do the jury clauses of the citizen participation, and in what ways, if any, are both the grand jury and the petite jury related to the principle of limited government? When you're ready, you may begin.
Comedian Norm Crosby noted that when you go into court, you are putting your fate into the hands of 12 people who weren't smart enough to get out of jury duty. Although hated by the American population, the jury is a method by which ordinary citizens, not legal professionals, participate in the judicial system. The Bill of Rights' recognition of the importance of the right to jury in the 5th, 6th, and 7th Amendments is a recognition of the importance of democratizing the judicial process. A democracy is defined as a government in which the supreme power is vested in the people.
By giving the power to judge guilt or innocence to the jury, the Bill of Rights grants the ultimate authority to the people. Because the jury meets the definition of a democracy, the jury fulfills the role of a democratic branch of judicial power. Despite the jury's importance to a free society, it goes too far to claim that it is more necessary than the representatives in the legislature. To elevate one branch or part of one branch, one another over another ignores the importance of the balances of power, a concept that the founders created in the centerpiece of American government.
All of the branches performing their functions and providing these checks are necessary to provide for a working government. As Justice Robert Jackson said, concurring in Youngstown Sheet and Tube Co. v. Sawyer, Company v. Sawyer, while the Constitution diffuses power, the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. It enjoins upon its branches separateness but interdependence, autonomy but reciprocity. One branch could not be successful without the protections provided by the others.
The grand jury's clause of the Fifth Amendment ensures citizen participation in the judicial process because random citizens are selected from the population and given the power to bring charges against a person, presentment, and to formally accuse a defendant of a specific crime, indictment. Jurors reason through the facts and evidence, much like a lawyer, to come to a conclusion that protects and promotes justice.
The Sixth Amendment's guarantee of an impartial jury in the district wherein the crime shall have been committed allows citizens to participate in local trials and judge their peers. This gives them a greater sense of participation and duty. When they can more clearly see the effects of their actions, they better understand their role in the judicial process.
Finally, the 7th Amendment illustrates the importance of civic participation in all aspects of the judicial system, specifically civil trials. When citizens are engaged in every level, from the federal indictments to local civil trials, they begin to realize the importance the importance and necessity of their participation in the judicial branch.
Old Whig number 8 states, Judges have been ever found much better friends to government than to the people. Both grand and petite juries put limitations on the power of the judges and the government. This idea originated in section 39 of the Magna Carta, when it stated that no free man is to be arrested or imprisoned or outlawed or exiled or in any way destroyed, except by the lawful judgment of his peers or the law of the land. The jury adds common sense to the law, which checks the power of the king and the judges.
Before government officials can force a defendant to suffer any anguish from a serious criminal prosecution, the grand jury must give full consent, acting on the majority rule on a jury of 23 citizens. Although the principles of grand and petite jury are to balance the power given to judges, the juries do not act as a check if they do not do their job properly. As when New York Justice Sol Watchler stated that grand juries could indict a ham sandwich if you wanted, only about 33% of law enforcement are actually criminally charged, which demonstrates the ability of a grand jury to fail its role as the common sense of the law and become simply a stamp for government action.
However, when a grand jury does do their job properly, it can limit government, like when they choose to indict or through presentment. Although petite juries are mitigating compared to grand juries, they can interpose itself on behalf of people's rights through jury nullification, as seen in the 18th century juries refused to convict Peter Zenger of seditious libel in order to protect him against what they viewed as an unjust law. Thank you.
441.
What would you rather serve on? A grand jury or a petite jury or trial jury? Why?
I would rather serve on a petite jury, because that means there has been enough probable cause for there to actually be a trial, which makes the case more interesting and more concrete.
I would also like to serve on a petite jury just because I love the concept of all 12 members being in affirmation of either guilty or not guilty, and so I'd love to be part of that, seeing the whole process of getting it 100%.
I would rather serve on a grand jury in the fact that you don't necessarily have to convince everyone in a petite jury that it just goes on the majority rule.
I would like to serve in a grand jury as well, mainly because it'd be interesting to see exactly the way that a group of 23 people is able to come to at least a majority consensus as to what exactly the charges are to bring against a person, and the fact that they're not deciding guilt or innocence like a petite jury does, but only if there's enough evidence to actually bring that to trial. And I think that'd be something interesting to see that we don't get to see as much of.
So it probably will not be news to you, but there's not that much civic participation in this country anymore. Does that not pose a problem when we have potentially a large group of citizens placed in an enormous position of power who are the deciding factor in how someone's life is about to go when they're not adequately informed about the law, especially if we're trying to limit government?
Well, juries have changed over the years because when they were formed, you didn't need to have a degree. You didn't need to go to law school. They were simply you'd apprentice under someone and then you'd become a lawyer. So juries' jobs were, knowing the law and interpreting the law and also knowing the facts. However, as it's changed more and as lawyers have become more professional, the jurors have had to interpret the law less and more just run these facts through 12 different mediums to see if they do fall under the law. So they're not really interpreting the law, they're simply following it and interpreting the facts. So no, I don't believe that this is an issue.
So if that's the case, you guys ended your testimony on the idea of jury nullification. Is it lawful to nullify laws today in the United States? Can jury nullification take place or can it not?
Jury nullification can take place, but not in the same way that it's been able to take place in the past, like when juries would not send fugitive slaves back to the place where they originated from, because of the fact that lawyers can't actively advocate that someone nullify the law. If a lot of times when they're doing the voir dire, they'll actually ask questions to try and see if a potential juror would be willing to nullify, such as do you have any beliefs that would infringe upon you from making a decision based solely on the law?
So I'd be struck down if I was?
Not necessarily, because of the fact that it could still happen if the conscience of the jury still felt that this was an unjust law and the people on the jury still felt like it was an unjust law. It would have to result from them themselves. They would have to exercise their own sort of civic awareness in order to actually nullify in their current state.
It is acceptable. It is allowed for jury nullification, although it's rarely seen in the fact that citizens don't necessarily know their rights to this jury nullification, and that
should be the judge's responsibility to
judges they tend to hide it more in the fact that they don't have that right, and they should tell them their rights, but in the sense that our citizen participation, going back to Kenny's question, is that it's so everyone's citizens participation is so low, and we don't necessarily know all of our rights, in the fact that this is our job as American citizens to know our rights into what we can do, especially when we're going into a jury and we're putting these people's lives at stake.
Judges actually aren't allowed to tell the jury that they have the option to nullify beforehand, because this is a conclusion they're supposed to come to themselves, and that's the issue with the balance of education, that they don't have enough to often come to this idea by themselves, and it's so rare, especially because they don't know about it.
Additionally, it's very important that the jury themselves actually, if they are to nullify, comes to that decision themselves. A study was done that showed that when the jury was presented with the option of nullification, they actually were more willing to see a sympathetic defendant and acquit them sympathetic character as the defendant, then they were more likely to think it's actually not based on the law. So it has to come from the consciousness of the jurors themselves and not from the ideas put into their minds by either the judge or the jury.
Is public trial protective of individuals or communities?
Public trial is protective of individuals, and especially the individual that is the defendant, mainly because having their trial public makes it much less likely that it puts more of what is actually being taken against them. It puts that on display for everyone to see. So if there's any sort of abridgment of their rights, it makes it so that it's very obvious to everyone, and it can't happen in private.
However, this also protects the community simply because it serves as an example to the rest of the people. When they can go in and watch this trial and see what's going on, they understand that if they break the law, they will be punished, they will be taken to trial. And so in a way, it does protect the community by educating them on what will happen, serving them as an example.
We'll stop there. You guys are lawyers, yes? Both your parents are lawyers? I want you to do this question in front of them. And I want them to hit you with jury nullification. This is why. You're going to have four lawyers, more than likely, who are going to sit across from you and judge you on jury nullification. You got to convince them that you are not. You have to convince them that you are not bashing lawyers for not promoting it or judges not promoting it, but simply promoting the idea of jury nullification as an important part of being on a jury. Does that make sense? And since I'm not a lawyer, I'm not trained, I know I have talked to many about jury nullifications, and it is a very, very passionate subject that lawyers have and judges have. Okay? And so that's something I think that would really benefit you in this. I thought you guys did a good job. I came at you for that particular reason. I shot at you for that particular reason. Because you're gonna get it. Because especially if you have